Nigeria, of course, pẹ̀lú bí mo ti làkàkà láti dé lu yìí àtún á dé bẹ̀ tán orí ọwọ́ bákan náà ni èyí iṣẹ́ àárín kò tó sí fọkànbalẹ̀ bí mo bá ń rìn lórí títì níṣẹ́ ni màá máa wo fẹ̀tùfẹ̀tù bí olè tó fẹ́ jáṣọ gbé lọ́jà torí tọwọ́ ọlọ́pàá bá tẹ̀ mí wọ́n kàn folúwẹ̀ sọkọ sí Nàìjíríà ní kódà bí mo bá fi lè kọjá aago 5 ìdájí kí n tó bọ́ síta nínú ilé tí home office bá ká mi mọ́lé tí mi bá mi nìyẹn bẹ́ẹ̀ sì ni gbogbo nǹkan tó ń fi àjẹ mi kójútà ìnúwé ìgbélú ìlọ.
ohun tó kéré gbà tó ti gbọ́ nípa ìyáàfin Tòkunbọ̀ Lágbàyé akọ́ṣẹ́mọṣẹ́ lọ́yà olùdásílẹ̀ ní iṣẹ́ Brightway Immigration and Asylum Practitioners ọgbà ní second floor 1416 Bowie Street Woodlands nílùú London. ẹ̀rọ ìbánisọ̀rọ̀ wọn ní 020-8309-8808 tàbí 0785605-072. ìwé ìgbélú ìrọ̀rùn bá dé lọ́dọ̀ ìyáàfin Tòkunbọ̀ Lágbàyé kàn sí wọn níbẹ̀ ní iṣẹ́ Brightway Immigration and Asylum Practitioners. Samuel mo ti wẹ délé lọ́pọ̀lọpọ̀ ìgbà tí mi bá ẹ níbo gan ló sùn.
Wò ó Gbádébọ̀ ọ̀rọ̀ ara mi ti sú mi lù yìí bí mo ṣe ń wo gan ó sígbà tí mi ò ní padà sílé.
Sílé ibo.
Nigeria, of course, pẹ̀lú bí mo ti làkàkà láti dé lu yìí àtún á dé bẹ̀ tán orí ọwọ́ bákan náà ni èyí iṣẹ́ àárín kò tó sí fọkànbalẹ̀ bí mo bá ń rìn lórí títì níṣẹ́ ni màá máa wo fẹ̀tùfẹ̀tù bí olè tó fẹ́ jáṣọ gbé lọ́jà torí tọwọ́ ọlọ́pàá bá tẹ̀ mí wọ́n kàn folúwẹ̀ sọkọ sí Nàìjíríà ní kódà bí mo bá fi lè kọjá aago 5 ìdájí kí n tó bọ́ síta nínú ilé tí home office bá ká mi mọ́lé tí mi bá mi nìyẹn bẹ́ẹ̀ sì ni gbogbo nǹkan tó ń fi àjẹ mi kójútà ìnúwé ìgbélú ìlọ.
ohun tó kéré gbà tó ti gbọ́ nípa ìyáàfin Tòkunbọ̀ Lágbàyé akọ́ṣẹ́mọṣẹ́ lọ́yà olùdásílẹ̀ ní iṣẹ́ Brightway Immigration and Asylum Practitioners ọgbà ní second floor 1416 Bowie Street Woodlands nílùú London. ẹ̀rọ ìbánisọ̀rọ̀ wọn ní 020-8309-8808 tàbí 0785605-072. ìwé ìgbélú ìrọ̀rùn bá dé lọ́dọ̀ ìyáàfin Tòkunbọ̀ Lágbàyé kàn sí wọn níbẹ̀ ní iṣẹ́ Brightway Immigration and Asylum Practitioners.
Brightway Immigration and Asylum Practitioners. It's the live program right now, direct from Nigeria 101.1 FM. My name is Tokunbo Lágbàyé. If you are just joining us for the first time, it's all about how to regularize your status in the United Kingdom. Eyamejoki Jasha. My name is Tokunbo Lágbàyé. My office is located on the second floor offices of 14 to 16 Bowie Street, London, SC18 6LF in Woolwich. And the telephone number in the office to reach me directly is on 0208 309 8808 0208 309 8808. It's a live program right now from the studio, direct from the studio. So if you're on my Facebook and you are out there driving, please tune your radio to 101.1 FM, and on my Facebook, please join us live right now so that you can benefit what I want to tell you and how we can resolve it. Each time you see me coming online, it's a legal talk. It's not an entertainment talk. It's a legal talk. It's an education. I want to continue to educate, most especially Nigerian in the diaspora, because there is a version in the Bible that says, my people perish because of lack of information. If you have that information at hand, you will not make mistake. You will not continue to waste money. The information is the key to anything you want to do in life. Be obedient and just listen and follow the instructions. If you follow instructions carefully, you'll be okay. Tokunbo Lágbàyé is a senior legal practitioner in the United Kingdom. She's also a solicitor qualified, so I know exactly what I'm talking about when it comes to the issue of how to regularize your status in the UK. Anytime you see me online talking about issues of marriage relating to status, it is live, it is real, it is not fictions at all. It is not to attack anyone. This is legal talk. there is no need for any otherwise than to give advice to anybody, regardless of your sex, regardless of your color, regardless of your religion, regardless of your attitude or behavior, anything. My job as a lawyer, I stand corrected, is to give advice, is to assist you. Whoever comes to me first will be my client. Listen carefully. Between husband and wife, whoever brings case first is my client, so that there will be no conflict of interest. There will be conflict of interest if I'm representing wife on the same matter and I'm representing husband as well. That is conflict of interest. At this stage, there is no conflict of interest with what I'm doing. The authority is aware of my presence. They know what I am doing. So they are happy because it's a right advice and it's on the highest level. There is no negligence in the advice I'm giving you, and at any time, I am willing and ready to defend my advice. So if you are there and you are taking advantage, take it correctly, please. When you want to get anything from me on the line without coming to my office, you need to make sure you get the right fact, right information. Don't get it wrongly, please. I beg of you. When I say A is my A. I don't change words. I am too blunt and too bold to change my sentence when it is already in the public glare. I don't do that. So when you are getting information from what I am giving out, I beg you, please listen carefully and make sure you get the right information so that you don't misuse it. To misuse it is an offense in the law. So please get the correct advice. And when I'm speaking online like this on media, make sure you get it right so that you don't give your friend wrong advice. Or alternatively, don't even give the advice because you're not qualified to do it. Push your friend to me and I'll deal with the matter myself. I am honored and I'm grateful to all of you joining me right now. You are the best thing. I know I recognize all of you, but I'm not in a position to be calling names. That is not my style. Even at home, when I love you, I recognize everything you are doing. I don't really show it, but my heart is showing it. I'm praying for you, but I will not step on toes. So thank you very much. I am humble and I will remain humble. Even those who are watching silently, I am humble. Thank you so much for all your support. You're all wonderful. You're all the best. I've told you, you are the best. Because anyone that is in the public glare like me, it is the support of the public you need most before any other thing. So thank you. You're wonderful. You are the best. I have to appreciate you. I have to acknowledge you. Because Bible gan sọ wípé inú dídùn ló máa mórí yá. Téèyàn bá appreciate ẹni tó ń ṣe nǹkan fún yàn, then you will be able to have a lot of people at your side. I am highly honored to have you supporting me all the time. Thank you. Thank you. Thank you. Thank you. Thank you. You are the best. Right, let's go into the real business of the day. I was in court on Monday, and I realized most of the mistakes being made by parents settled in the UK. That prompted me to the topic of today. I was in court on Monday, and I realized the mistake made by parents settled in the UK. Hello, can you lower your radio, please?
Hello, can you lower your radio?
Alright. Yes, sir.
Hello, live and direct in the studio right now, Tokunbo Olagbaye program.
Yeah, I'm watching you live on Facebook. I just want to have some advice on some application.
Right.
We applied for the EU permanent resident, and they sent the letter is going to take 6 months, and it's been like 4 months now. Is there any? It's been like 5 months now without no reply, and they asked us not to come out something. So what do you think we can do in that case?
They are not in breach at the moment, so you have to stay cool. You have to relax at the moment. There is nothing you can do currently because they told you not to call them until after 6 months. And the way things are since last year, about middle of last year, since last year now, a very good practitioner will sense it that there is a problem inside now. So backlogs. So you might even likely not to hear from them until after 6 months because it's really heavy inside now.
So what is? I should just stay cool.
You should just stay cool. That's it.
All right.
Okay.
All right. Thank you very much. Do you have any idea what problem is going on?
That's what I just said now. It's a backlog.
All right.
So there's a huge backlog within the administrative section from Home Office to court, from court to Home Office. So cases are building up unnecessarily. In fact, it's affecting office as well because we have so many cases that it's been in there now for 6 months or more. So, but the response is we will get back to you. That's just the response coming up now. So don't worry, finger crossed. As long as there is evidence that they've taken money that you've paid for the application from your account, that's what you need to be worried about. If the money has not been taken and you have not received a response from them to acknowledge your application, then there is a problem somewhere.
Okay.
So
Thank you very much, ma'am.
You're most welcome, sir. Thank you. Bye. Bye.
Yeah.
Bye. So yes, let's crack on. Let's talk about the issues facing parents that are settled in the UK that want to bring in their child from overseas country like Nigeria, typical. What are the issues that the Nigerian parents settled in the United Kingdom needs to be aware of? I was in court on Monday, and this prompts me to the idea of talking about this problem straight away because I want people to learn from it. Most especially is the issues of parents not parents, where you have one parent settled in the UK and the other one is overseas, but they are not in relationship together. If they are not together anymore, who is taking care of that child? The Secretary of State is worried. And majority of the time, it is evident that the parents in the United Kingdom it's so careless of leaving that child back there overseas for a very long time, and then all of a sudden realize that the child is coming to be 17 or 18 and now hustling to make an application for that child to join him, most especially him, in the United Kingdom. Now listen carefully if you're out there. Every time that cases come up like this that I discuss with you, it's real life story and I want solution. I want to give you the solution to it quickly so that you learn from other people's mistake. It is a live program right now. I'm in studio. I'm in the United Kingdom. My name is Tokunbo Olagbaye. If you are just joining us, it's still on the same issue, the same topic on how to regularize your status. What I'm discussing at the moment is the issues facing settled parents with regards to bringing in their under 18 child from overseas country, e.g. Nigeria. What do we need to do? How do we need to go about it to resolve this problem? Most times, parents will put in an application that they want to get their child in. They will not use lawyer and they think they're competent and fluent to write the good English to get it done. But it's not like that. Hello?
Hello, ma, ẹ káàsán, ẹ kú iṣẹ́ wa o.
Ẹ káàsán o, yes ma.
Àbíkẹ́ ló ń sọ̀rọ̀ mà láti South East náà.
Okay.
Ẹ jọ̀ọ́ mà, á ní kàbẹ̀rẹ̀ ẹnìkan ní fẹ́ bá bẹ̀rẹ̀ question mà.
Okay.
Wọ́n gbé kinní wọlé á refuse ẹ̀ wọ́n ní kó máa lọ. So voluntary letter náà tún tẹ̀lé pé wọ́n máa pè é. Pé ní ìmọ̀kọ́ tó máa béèrè lọ́wọ́ yẹn lára nípa béèrè pé ṣé wọ́n máa wá fipá mu àbí báwo mà.
In the first instance, irú application wo ló gbé wọlé kó tó di pé àwọn yẹn ní kó fìlú lẹ̀?
Ọlọ́mọ ó ti kọ́kọ́ gbé kọ̀ wọlé tẹ́lẹ̀ pé àtọmọ kọ́mọ tó pé 7 bọ̀ nísìnyí àwọn yẹn ti pé ó lọ́mọ 8 àti 5 lọ́wọ́ mà.
Ṣé ńgbà tọmọ yẹn wá pé 7 ṣó gbé new application míì wọlé to back it up?
Wọlé ó gbé mi wọlé bọ̀ tí ṣe wọ́n tún wá lọ fi ń wo ti tẹ́lẹ̀ tó wàá wo ti tọ́mọ ti pé 7 torí wọ́n fún ọ ní right of appeal.
I need láti mọ nǹkan tó wà ní application yẹn, so the best way forward is to come for consultation and bring that document first as soon as possible then.
Okay.
Yes.
Ṣé wọ́n máa gbé ìyá àtọmọ lọ ni?
Me ò mọ nǹkan tó wà ní application. I will not give any information now because I need to know the background. She understand? Tí n bá mọ background, then that will give me the opportunity to advise correctly. But I don't have the background, so I won't give advice on it.
Okay, ṣé gan-an.
It's all right, ma. Thank you, ma. Bye bye. Hello. It's still a live program on Naija 101.1 FM. My name is Tokunbo Olagbaye. The question the young lady asked, because anyone that is under 99 years, under 100 years, I love to call them young ladies, so you have to pardon me because they don't want to get old. So I want to accept that they are young. Hello? Yes. Emma Kasan. Me, Leranti, a lot of people will say they want to come and see me, and they have come.
Yes, ma'am.
Yeah.
I saw you on Facebook. I called you about 3 weeks ago.
Okay.
That I said my husband is a commissioner of police.
Are you happy to discuss on the media now?
Mommy, I don't want to discuss on the media. I don't want to make it public.
Public lawa.
Okay.
So come off quickly. Come off.
Okay, ma'am.
Still on the same issue, and we want to talk about the parent that has settled in the UK, the problems they are facing in getting their under 18 child into the country to unite with them. There's so many problems now. There are too many of them now that they are facing, because parents think that they are fluent in writing and they have studied English, so they can put in an application by themselves. But one thing that they have forgotten is that they are not qualified, so they will not know the loophole. Unless you have that touch, you will not have the in and out of what is expected of you when it comes to putting an application. The rules are obvious and they are just laid out there for decoration. It's academic. It is academic. What is crucial is the practical aspect of it that is not directly disclosed to the public at large. What you are seeing in the books or internet on the guidance is just academic. The one that is practical is the one that people like us take to court all the time and listen to the judges when they are coming out with their opinions in their decision determination. That is what is practice, what's called practical. That's practice. The academic one is just the one that Dick and Harry can read, and it's there. Now I want to go straight to the point so that we don't waste each other's time. Ìwọ tó fẹ́ gbé ọmọ ẹ̀ wọlé láti Naija, jẹ́ kí n sọ Yorùbá díẹ̀ kí n tó tún lọ fi òyìnbó sí so that kí n lè assist àwọn tó fẹ́ really benefit. Ọmọ yẹn wà ní Nàìjíríà. For example, ìwọ wá wọlé, o ti wọlé ní Nàìjíríà sí Britain ní 2003. Typical example of that case tí mo ní lọ́wọ́ nìyẹn tí mo gbé lọ court. O wá wọlé ní 2003. 2003 tó wọlé bọ̀ yẹn, o wọlé wá ti wá marry láti wá join obìnrin mi tó pàdé ni. Tó ti níwèé ìgbèlú tó wá ṣe ìyàwó pẹ̀lú ẹ tó wá mú ẹ padà bọ̀ wá sí UK ni. Nígbà tó wá ń bọ̀, listen carefully, when you are coming to England, o ní ọmọ lọ́wọ́, and that child is quite young. At that time he was only 2 years old. Máa gbọ́ mi dáadáa o. You now left that child with an appropriate adult, an elected person that you trust, a trusted and a confident person. So the child was with that guidance for those years period, throughout those period. And you have left your country in 2003 as a spouse of a person who is present and settled in the UK. Má gbàgbé o, you are a he. Ó lè ṣẹlẹ̀ sí she náà, but you are a he. Nígbà tó wá dé England, tó marry, tó gba the first 2 years náà fún ẹ ńgbà yẹn tó ṣà fún ẹ anyway. Ó padà immediately within 6 months, ó lọ yẹ ọmọ yẹn wò. Evidence there wà. Listen dáadáa o. Lẹ́yìn 6 months tó padà lọ yẹ ọmọ yẹn wò, ó padà lọ lé mọ́ fún ọdún méje. 2 years ló fọmọ yẹn sílẹ̀. Ọmọ yẹn ti ṣe, ó ti pé 9 years nínú ọdún méje tó fi lọ lé mọ́ yẹn. Ó wá sọ pé ó máa make contact pẹ̀lú ọmọ yẹn. Òótọ́ la rí pé òun send owó sọ́mọ yẹn, but báwo ló ṣe make arrangement development ọmọ yẹn tọ́mọ yẹn fi lọ léèwé toró ti pé 9 years, school tó lọ ta ló ṣe arrangement fún, owó school tó ń san báwo náà ṣe, aṣọ school tó ń wọ̀, àwọn ìwé tó ń lò, bóyá ó lọ sí school dédé tàbí kò lọ school dédé, bóyá ó ń fọ eyín tàbí kò fọ eyín, church wo ló ń lọ, mosque wo ló ń lọ, ta ló wà ní in charge àwọn decision ìwọ̀nyí lórí ọmọ yẹn for that 7 years. Má gbàgbé o, parent ni ẹ́, the other parent is not in picture any longer. She has decided before you even left your country ló ti gbé ọmọ yẹn sílẹ̀ fún ẹ. You are a man. She left you with a 2-year-old child, and she has gone out of both of you's life. You were saying in between that you have no knowledge of her whereabouts, and the child was left with an appropriate adult to be taken care of. You now elected another confident friend of yours who is a he to be sending money to the guardians to take care of that child. So tó bá send owó láti bí báyìí, ó máa send owó sọ̀rọ̀ ẹ̀ yẹn ni níbi tó wà. Ọ̀rẹ́ ẹ̀ yẹn ló wá ń pass owó yẹn sí ẹni tó ń tọ́jú ọmọ yẹn nílùú yẹn. Now ó wá make application, ó sọ pé ó ti lọ visit ọmọ yẹn lẹ́yìn 2010 yẹn, the first time tó visit after 2003. Ó visit ní 2010. Ó dẹ̀ visit sometime 2011 or 12. Then another one be at 30. Ó ṣá visit lẹ́ẹ̀mẹ́ta before you now submitted an application in 2015 for him to come and join you in the UK. Now the issue here is that 2003 to 2010 tó fi gbé ọmọ yẹn sílẹ̀, kí ni evidence pé o ní responsibility lórí ọmọ yẹn? Àkọ́kọ́ nìyẹn. Nígbà tí wọ́n interview ọmọ yẹn on an application, ìyá ọmọ yẹn ti visit ọmọ yẹn ní 2011 before the application. Nígbà tí wọ́n fill the application yẹn, ó ní o mọ whereabout ibi tí ìyá ọmọ yẹn wà ló sọ pé ó ti rí mọ́ láti bá tó ti gbé ọmọ yẹn sílẹ̀ tí wà tí ẹ ti separate. But nígbà tí wọ́n interview ọmọ yẹn, ó ní ìyá òun wá rí òun ní 2011. Pé òun rí ìyá òun. When last did you saw your mother? I saw my mother in 2011. But on the application you filled out, you have said to the entry clearance officers that you have no knowledge of the mother's whereabouts since she has left you and the baby in 2002 or 1 before you came back in 2000, before you joined your new spouse in 2003. The entry clearance is not satisfied with what you have explained on your application form. There was no any evidence that you have sole responsibility of taking care of that child, because there is Mr. A you send money to. There is Mrs. B who is the guardian in charge. There is Mrs. C who is the biological mother. So it's an area of concern. At the time you submitted an application, you only submitted to the entry clearance officers a bit of document to show that you are maintaining that child. You did not even put anything in there as to communication that you have contact. So application was refused on the basis that this entry clearance is not satisfied that you have day-to-day responsibility of your child. You see, according to the Home Office phrase, sole responsibility is intended solely on you to reflect and show that you have that parental care on your own without sharing it with anyone over that child. Your argument is you are overseas, so there is no way you can have that day-to-day responsibility. Of course you can. Of course you can. Bear it in mind that even in the UK, while you were with your children here, you phoned them in school and said, "Níbo lo wà? Ìgbà wo lo máa délé? Ṣé bẹ́ẹ̀ ti close? Máa gbálé lọ." That is parental responsibility. Ṣé o ti ṣe coursework wẹ bó ṣe wà ń bíṣẹ́? Kí ló ń ṣe lọ́wọ́ nísìnyí? Láàárọ̀, you are a doctor, or you are a care staff, you are in the hospital already working. So you are phoning that child before he leaves home and say, "Kúrò nílé o, because of traffic wà lójú ọ̀nà, tètè máa lọ ní ìsìnkú tó pé o get stuck in the traffic." That is parental responsibility. So the same thing should be passed on to the child overseas as well. You cannot just leave that responsibility to the person that is taking care of that child for you. You have to assign that person. You have to tell that person exactly how you want your child to be brought up. You cannot afford to make that silly mistake. Bear it in mind, 95% of overseas applications are meant to be refused. it is now down to individual in that matter to show that the case is authentic, is genuine, and bring it back to the UK court to challenge. You see, if you cannot accept the scenario that they have trained the entry clearance officers to refuse overseas application, then you'll be wasting time. It is important that you understand that if you are the parents, you are in the UK, what is crucial is that you need to demonstrate sole responsibility. You must have a form of qualifications to show that in that area that you are in charge, because it is intended solely on the parent that is settled in the UK to show that they have that responsibility before they can bring that child to the United Kingdom, in order not to be a slap to the other person over there. So you cannot just want to bring a child in because o ti fẹ́ pé 17 or 18 o fẹ́ kí law yẹn cut off pẹ̀lú law. Kí ni ò ń wò láti ìgbà tó ti gbàwé ìgbèlú? Look at my scenario. Ó ti gbàwé láti 2003. In the first instance, the first question that was asked, why can you not make application along with that child to bring that child in when you were coming? Because you have already told that lady that you have a child. You have a child that you are solely responsible for. So kí ni reason tó fi lè make application for ọmọ yẹn? The answer was that the child was too young. And the second answer was that he is coming to a country that he has no knowledge of. And he is not settled. He needs to know what is going on there before he can bring in a 2-year-old or 5-year-old child acceptable in the eyes of the law. That is a nice response. That is fine. That is on one-to-one with the judge. You will not be able to write that successfully with the entry clearance because they're not going to accept that. But the crucial one that I want people to really understand is that the gap between the 2003 and 2010 is crucial. Kí ni o ti ń ṣe láti ìgbà tí o ti wọlé ní 2003 yẹn tó ti padà ní December tó ti lọ yẹ ọmọ yẹn wò tó bá padà sí England? Kí ni àwọn responsibility tó fẹ́ show wípé you have that sole care of that child? Even if you said that you may have had the sole responsibility for the child's upbringing in another country, it is obvious that you have to show that you have it on a day-to-day basis, and you make that day-to-day decision in the upbringing of a child, which are bound to be decided on the spot. The decisions are bound to be decided on the spot by whoever is looking after that child overseas in your absence. So you need to make parental responsibility. You need to make a sole responsibility. You need to make a day-to-day decision. Instead, Mrs. A, who is taking care of that child, that listen, Mrs. A, mo fẹ́ kọ́ ọmọ yẹn lọ sí school yẹn mọ́. Wọ́n sọ pé wàhálà school yẹn pọ̀. Ẹ bá mi lọ sí school bí eléyìí mo ti ṣe research ẹ̀. Ẹ lọ bá mi béèrè lọ́wọ́ head teacher wọn kí ni àwọn requirements wọ́n need kí ọmọ yẹn fi lè máa tó fi máa wá sí school yẹn. You need to have the telephone number of the head teachers or the school or the sport master or whoever is in charge. Tó bá wà ní boarding school, you need to have the telephone number of the hostel teacher to one in charge. You need to be having the day-to-day responsibilities and find out exactly how that child is doing. You cannot dump a child in a dormitory in a boarding house and be paying school fees heavily without knowing the status of that child. For example, tí o bá mọ orúkọ school tó mẹ́wàá presently, you will be killing yourself on your application. You need to know the school that child is attending. You need to know what year he is. You need to know his achievements. The majority of the parents that I have seen so far has no knowledge of what that child is doing. Ọmọ yẹn máa parọ́ fún wọn. Ó máa sọ wípé òun wà ní grade kìíní kan or secondary school kan báyìí òun ṣe dáadáa. Report sheet yẹn dà. Where is the academic report? It is crucial that we have academic reports. Hello.
Hello, ma.
Ẹ káàsán o.
Ẹ káàsán ma.
Yes, sir. On point, kí lorúkọ yín àti ibi tẹ́ ti ń pè?
Kazeem ló pè láti Danina.
Okay, carry on.
Yeah, please. Ọ̀rẹ́ àbúrò mi ni ìyàwó ẹ̀ ìhì ló fẹ́ EU national. Wọ́n fẹ́ra wọn ni. Right, láti last over 2 years now. Ṣé get me ma?
Mo ń gbádùn yín.
But wọ́n lè fi ṣe but wọ́n ní appeal ó lè ṣe appeal but wọ́n fẹ́ bẹ̀sẹ̀ ní àti àjọ argue ọ̀pọ̀ wọ́n á ní okay ṣé tó bá dé court ṣé wọ́n lè argue 2 years living together ni ó lè invite mọ́mí ẹ̀ náà ní last year ìyàwó ẹ̀ ló invite mọ́mí ẹ̀ wọ́n lè jọ gbé application ẹ̀ wọlé nìbọn wọ́n lè review wọ́n fún mọ́mí ẹ̀ ní visa based on ìpè àwọn àti partner ẹ̀ lọ́jọ́ invite wọn but wọ́n pe pàtẹ́ tó ní court ní next month ní ọ̀dà tó next month ní court ẹ̀ ó lè ti kó bá 2 years tó wà ti ìyàwó ẹ̀ wọ́n lè jọ ń gbé ní kéṣe bóyá pé wọ́n jọ ń gbé wọn tí ì bímọ.
Okay.
ṣé kò lè argue kí ní ẹ̀ ní court ipe àwọn ti live together based on wọ́n erase the marriage ẹ̀ kúrò.
The question here is that at the time of application, ṣé wọ́n ti gbé papọ̀ for 2 years?
The time of application.
At the time, ṣé wọ́n ti gbé papọ̀ for 2 years?
No, wọ́n ṣe pé wọ́n ṣe over 2 years ní sin after that wọ́n review ẹ̀ tó dé lọ bá pay gbogbo things like that.
Nígbà tí wọ́n wá submit application, kí ni basis náà fi submit ẹ̀?
Based on pé marriage.
Bọ́nà ti ṣe marriage yẹn.
Nigeria ló ṣe.
Ṣé àwọn méjèèjì ló travel lọ ṣe?
No.
Ẹ má bínú. Ẹ má bínú, wọ́n máa jẹgba. Nítorí pé they will have stayed back here in England.
Okay.
Yes, they will have stayed back here in England and get it done. There is nothing called marriage in absentia. Ẹni tó bá wà bẹ́ẹ̀ kó máa gbọ́ mi. It takes two to tango. Engagement, traditional wedding, that can be done in absentia. But when it comes to white wedding, registry can never be done in absentia. Àbúrò mi ò lè represent heart mi ní marriage.
No, where?
Yeah?
Which court marriage, no, our marriage local government ni. Because both family parents are
what they issue certificate.
Yes, when you certificate.
It is wrong in the eyes of any jurisdiction. Àti registry o, àti local court o, èèyàn méjì tó wà ní ìgbéyàwó ló ní certificate.
Okay.
The law says in any ramification in all over the world, both parties must be present at the ceremony.
Okay. So
let me take you through easily.
Okay.
If you manage, if the applicants, if appellant still, applicant, but the appellant wrote to one court, if that appellant managed to have a good judge,
okay.
And no radio, you that can concentrate. If ìbàjẹ́ court marriage, ìbàjẹ́ local marriage, and tó ń dá mi lóhùn yẹn kò matter. Èyàn méjèèjì tó bá wà ní ìgbéyàwó lé kó wà ńbẹ̀ tó ní relationship yẹn, whether court marriage or nothing, you have to think about the immigration here. Ẹni tó ń reply mi lọ́wọ́lọ́wọ́ yẹn kò matter. Whether court marriage or registry marriage, èyàn méjì tó wà tangle in that relationship lè kó present, that's the law. And nothing will change. The Home Office will not accept in absentia. When you are bringing it to the Home Office, gbàgbé absentia will work with the Home Office. That's the point. Now let me go back to your answer here and let me answer a question and answer you. Charity, ẹni yẹn bá bá ojú rere Ọlọ́run àti ti èèyàn pàdé. Torí ohun gbogbo wà lọ́wọ́ orí. Judge máa determine case yẹn as at that day tó fẹ́ wá sí court yẹn.
Okay.
Ẹ máa gbọ́ mi dáadáa o. Tí ó bá bá ojú rere Ọlọ́run àti ti ènìyàn pàdé, mo fi síwájú. Judge máa determine case yẹn as at the date tí wọ́n wà ní court. Tó wà ní court fún hearing yẹn.
Okay.
Tó bá determine ẹ̀, kó tó lọ, ẹni kó lọ bá lọ́ọ̀yà ẹ̀.
Okay.
Kó lọ ṣa gbogbo evidence of living together for 2 years.
Okay.
Kó lọ ṣa evidence tán fi invite màmá wọlé láti oversee tí wọ́n dẹ̀ fi accept ẹ̀ pé wọ́n wà ní marriage, wọ́n dẹ̀ fi gbé wọlé.
Okay.
So tí wọ́n bá ń bá kan lọ tí kan bá fẹ́ yíwọ́, wọ́n á lo backbone, wọ́n á lo B fún plan B wọn.
Oh, okay.
So the plan A ni pé wọ́n kọ́kọ́ máa argue lọ on a point of law pé ṣebí marriage yẹn tí wọ́n bá accept ẹ̀, why tí wọ́n ṣe accept ẹ̀ kan fi gbé màmá wọlé.
Yes. Mama, it's because one of the
So one mama argue case yẹn lọ first on that plan A yẹn nìyẹn pé entry clearance kàn wà academic lásán pẹ̀lú reason for refusal ni kò wà practical wípé because kan wo ṣe home office tí ẹni kò ń ṣe entry clearance home office ni pé ṣe bí home office realize pé wọ́n ti invite mother in law wọlé wọ́n dẹ̀ ti gbé wọlé wọ́n dẹ̀ ti accept pé wọ́n ní marriage ó wà ní relationship náà ṣe gbé wọn wọlé tán ṣe accept ó máa argue case yẹn lọ tó bá ní confidence but during the time tó argue case yẹn lọ ó máa kó sí ọpọlọ judge náà at the same time pé in the event tó o bá ti accept pé marriage yẹn in absentia tó bá sọ pé in absentia náà ṣe marriage yẹn ó gbà kí ló máa ṣẹlẹ̀ sí cohabitation of 2 years of living together document ni sir.
Bless you. My lawyer. That convince me.
So you have to really put it through properly wípé kó tó submit bundles fún home office fún court fún ti ara wọn kó tó prepare gbogbo bundles yẹn wọ́n gbọ́dọ̀ kó evidence of 2 years of living together sínú document yẹn.
Okay.
Wọ́n dẹ̀ gbọ́dọ̀ kó gbogbo responsibility náà fi invite màmá wọlé gbogbo document náà pé màmá wọlé everything kó gbogbo ẹ̀ sínú ẹ̀.
Okay.
Tí lọ́ọ̀yà Yorùbá lè ṣe gbé wá síwájú mi.
Matter, fún mi nọ́mbà ọ́fíìsì yẹn so máa pé ìrọ̀ mi àti ẹ̀ máa wà because bẹ́ẹ̀ tẹ̀lé sọ̀rọ̀ yóò dẹ̀ tó máa switch lọ́dọ̀ lọ́ọ̀yà yẹn. Fún mi nọ́mbà yẹn.
As long as it's real and it's authentic and it's genuine and both of them are ready to present in court, bring it to my desk.
Yes, they are ready because they are ready to deport ìyọkọ̀ àti ìwọ̀n ṣe pé bóyá kìíní kan. They are ready to the same house is anything. They are prepared for the go to home office as well.
That's fine. That's fine.
They are ready to go there.
That's fine. That's fine. There's no problem. Bring it to my desk.
Okay. Come to your office.
The telephone number for my office is 0208
All right, 0208
309
309
8808.
808.
Yeah, 8808. That's 8808.
Okay, 8808.
Yeah, 8808. Okay, so thank you for calling. Thank you. Yeah, bye. So let's go back to the point we are talking about with regards to the parents that are settled in the UK that want to bring their child into United Kingdom to join them. It's all about the issue of having that sole responsibility. And if you cannot prove it that you have that sole responsibility, it's going to be very difficult for you to have a successful application. Majority of the time, 90% of cases that come to my desk, it has already been done by the individual, by the applicants themselves. It is when they refuse them, they will not bring their headache onto my desk to have a look at. I don't think I have ever, only a few cases that come through my desk at the beginning. The majority will be the one that they have refused and they now realize that there is Mrs. Olagbaye somewhere. Let me go and give it to her to have a look. The judge is looking for the idea of what we call parental responsibility. So you need to be aware what are the things that the judge is looking for. Like I said earlier on, you have to make sure that the school that the child is going to, you are in charge. In your absence, you have selected that school and you ask the guidance to go there. You have to make sure that you know the breakfast that child is taking, the type of food the child is taking, whether he washes clean, he has a clean teeth or not. You must be in charge. Enough clothing, enough clean clothing. You have to make sure that you are in charge. There is so much to talk about when it comes to parental responsibility. I'm coming. Hello.
Hello, ma.
Ẹ káàsán sá o.
Yes, ma. Orúkọ mi ni Ibrahim láti London.
Okay, carry on.
Mo ní ìbéèrè kan ni ma. Mo fẹ́ bẹ̀rẹ̀ pé àwa tí a ò tí lówó. But mo á dé nìkan ní Nàìjíríà tí mo ń fẹ́. Mo á wò pé ṣé bóyá tó ń mú wá. Bẹ́ẹ̀ ni pé tọ́nà bá dé gbàdúrà láti bẹ̀. Nígbà mo fẹ́ bẹ̀rẹ̀ yìí pé advice mi lé lórí ma.
Mo ti mọ̀ tó ń sọ̀rọ̀ ẹ lè gbé wọlé, but you know that when it comes to bringing in a person from overseas, ṣé kí n máa sọ̀rọ̀ lọ?
Ẹ máa sọ̀rọ̀ ma.
Ohun tí òfin sọ lọ́wọ́lọ́wọ́ ni pé ìwọ tó bá fẹ́ gbéyàn wọlé, you need to have an invitation letter láti gbé ẹni yẹn wọlé. Ẹni tó bá dẹ̀ máa issue invitation letter gbọ́dọ̀ ní ìwé ìgbèlú nítorí pé ó máa fi passport ẹ̀ àti ó máa fi copy passport ẹ̀ ó máa fi pay slips ẹ̀ sí, ó máa fi proof of address ẹ̀ sí, ó máa fi bank statement sí wípé òun kójú òṣùwọ̀n láti gbéyàn wọlé. Ẹ má gbàgbé tó bá dẹ̀ gbé wọlé gẹ́gẹ́ bí àlejò ó fẹ́ gbé wọlé pé ẹni yẹn máa padà so láti show pé ẹni yẹn máa padà so ẹni tó fẹ́ gbé wọlé yẹn gbọ́dọ̀ show pé òun níṣẹ́ lọ́wọ́. Tí ẹni yẹn ò bá show pé òun níṣẹ́ lọ́wọ́ pé òun níṣẹ́ tó máa padà sí tàbí òun ní community ties ní Nàìjíríà wọn ò ní fún ní visa o. So that's just it. Okay, there. All right, take care there. Bye. So we're still talking about the same issues on how to regularize status in the United Kingdom. So I'm talking, and I don't want to leave that particular topic. We can come on another topic next time when I come on here. But for today's topic is about parents having sole responsibility on that child that is in Nigeria. Because you cannot just wake up overnight that you want to submit an application for a child that is going to be 18, that is already 17. Judges are very wary of this. They are very worried. They are concerned. Even the secretary clearance is asking question. Why did you leave it to the last minute? It's just to give an immigration, to make an immigration advantage. It is not because you have a sole responsibility. That is not the reason why you are bringing that child into the country. You are bringing that child into the country because you know the child is going to be 18 very soon. So you quickly want to take the advantage of that immigration rule. Of course, it is your entitlement to bring in your child that is in Nigeria, that is elsewhere, that is non-European country, as a settled person in England. That is your first-class entitlement because you are the parent. But then the law is saying that your entitlement is not automatic when it comes to coming to them under immigration rule to bring in that child. You need to show that you are a responsible parent. You are not just a parent afenuje. Amolọ́mọ mi Nigeria, ọmọ mi wà ní private school ní kíní kan, ó ṣe kíní kan. Do you take care of that child? Do you have sole responsibility on that child? What the law is asking you is pretty straightforward. So you need to be able to demonstrate that you are in control. If you can't show that you are in control, application is not going to be successful. Like I said earlier on, what are the things that we need to show for the Secretary of State or our entourage overseas to accept the fact that you have the sole responsibility? You see all the documents that you have been sending money with to show that you have been maintaining that child since you came to the country. You need to have it. I will be very worried as well if you have your paper, your permanent settlement in 2005. I will be very worried. I put myself in their shoes when it comes to decision making. I'm going to be very concerned. If you have your settlement in 2005, 2006, and you did not make any effort or bother to bring in that child until later on in life in 2015, when the child is going to be 18, I'm going to refuse you. I will refuse your application big time. I want you to meet me in court if you can. I'm going to refuse that application if you have got your settlement in 2005 and I'm an entry clearance officer representing the Secretary of State for the Home Department overseas, and your situation comes to my desk and you only make your application in 2015 to bring that child in when he was 17, I'm going to refuse your application big time. I will refuse your application and I will give you right of appeal under human rights. It is now down to you to convince me if you can when we get to court. If you come back to my desk and ask me to review it, you need a lot of explanation to make before my desk, before I will accept the review and allow that child to enter UK. But having said that, if the case come back to me in England as a judge, I've switched my position. After being an entry clearance officer, and I've refused your application because you only made the application in 2015, and you have got your settlement in 2005. I have given you right of appeal because I have failed to review it for you, to change my review again. But I have now switched my position. I am now a judge in the United Kingdom. Your case has come before my desk. I will be expecting you to have the following to convince me to allow your appeal. I want you to show to me that you have a day-to-day responsibility over that your child. I want you to convince me and tell me the reason why you could not make an application straight away when you get your settlement status in 2005. I want you to tell me the reason why you have to delay it in 2015 when you knowingly know that the child is going to be 18 soon. I want you to convince me on paperwork. I want you to satisfy me with documentation. I want you to tell me on oral evidence when my home office OPPO is asking question, or the opponent or the solicitor representing the applicant is asking question. I want you to convince me why I'm sitting as a judge, to tell me the reason why I should allow your appeal. So for you to convince me, I want you to show to me the day-to-day responsibility you have over that child. I want you to provide documentation, the maintenance, the accommodation over that child where he or she is staying. I want you to send me a letter from the guidance to tell me the reason why the guardians cannot continue looking after that child. I want you to show to me where the mother of that child is. If you cannot prove to me that the mother of that child is not in that child's life since you have left, your application will fail and appeal again. Because there is evidence that the mother is still there, and you only want to bring that child in for the purpose of late minutes that is going to be 18. So you now realize that you want to give that advantage of education. But you need to show where the mother of the child is. Now let me answer a question quickly from somebody who is saying that what if you have a minor that is not your child but your partner's? That is another question that is another case that I have taken. It's not a problem. As long as you marry to the partner, or you and that partner are living together and you have been living together for over 2 years and you are both in the UK, if you have a settlement status, that partner of yours must also have a settlement status to have a smooth application. If he doesn't have a settlement status and that partner has a limited leave and you are not married, even if you are married, the status of what the biological partner has is what they will give to that child when coming to UK. And that is if they have accepted that the partner has a sole responsibility over that child. Your question is, what if you have a minor that is not your child, but it's for your partner? That is fine. But if your partner has not got a settlement status, that's going to create a problem. The studio number is 07496 936 110 for those who are asking. Studio number is 07496 936 110. 07496 936 110 is the studio number. We are live right now. So if you want to call in and give me the example that you have, that is fine. But the answer to the person that asked question is, if that child is not yours, how can students have permanent stay in the UK now? You have to show that you have been living in the United Kingdom before the changes in the law for you to have your 10 years lawful residence, and you have to continuously be applying and renew as a student for 10 years. If you are managed to be in the UK for the last 8 years, 9 years as a student, you will definitely have your indefinite leave to remain as a student. The only way to have your settlement status is if you have continuously lived in the UK for 10 years. If you have not lived in the UK for 10 years, you're not going to have it. Hello?
Hello?
Hello, your name and where you are calling from. Thank you.
Yeah, I come from London. My name is Tom Sigoji.
Okay, carry on.
Hello?
Yeah, carry on.
Yeah, please, I want to explain something to you, please. Can I speak in Yoruba?
If you are very fluent in Yoruba, why not? Can you carry on? Hello? Can you carry on with your question? Because a lot of people are waiting.
Okay.
Ask.
Your mommy.
The question.
Mo wá sí ìlú ní 2005.
Okay.
Hello?
Okay, mo ń gbọ́ yín.
Mo wá sí ìlú 2005. January 2005. Wọ́n ṣàmúlò ní ẹ̀sì láti wọlé sí ìgbà.
Ẹ máa sọ̀rọ̀ lọ, mo ń gbọ́ yín. Ẹ máa sọ̀rọ̀ lọ.
Ìgbà tó mú mi.
Ẹ máa sọ̀rọ̀ lọ, mo ń gbọ́ yín sẹ́ẹ̀.
Ìgbà tó mú iṣẹ́ àwọn importation cap fún training ọ̀ṣà. Wọ́n ti nílẹ̀. Ìgbà tó ti nílẹ̀ láti ọ́gbìn lọ sí ilé ẹgbẹ́. Ìgbà tó ti nílẹ̀ ọjà fúnlẹ̀ láti court. Ìgbà tó ti nílẹ̀ láti court. Ọ̀gbẹ́ wá sọ pé mo lọ mo ní máyísítà mo lọ. Pálí mi.
Ṣé ó ń cut off ni? Hello?
Hello?
Ẹ̀yin rédíò yìí sílẹ̀ because ẹ̀yin ń gbọ́ voice padà, and that's what is affecting you. I think that line is not very good, so I think it's cut off. Let's continue with our chat here and talk. Okay. Hello?
Hello.
Yeah, can you hear me? Ẹ káàsán sá. Orúkọ yà tìbí tẹ́ ti ń pè kémọ́.
Sunday lórúkọ mi láti Edmonton.
Okay.
Ẹ jọ nípa regarding the European issue. So mo ní pẹ̀lú partner mi gbé ìlú wọlé as we are living together for 2 years. So wọ́n refuse me but wọ́n fún mi ní right of appeal nígbà yẹn. So ìgbà tí appeal yẹn dé a lọ fún hearing mo bá àánú Ọlọ́run pàdé lọ́dọ̀ jọ́ọ̀jì yẹn ó confirm Ọlọ́run máa láwọ appeal yẹn ó ní kí n dúró fún òun for 2 weeks. So tó máa tó 3 weeks jọ́ọ̀jì yẹn bá nǹkan tó kọ ní wípé there is a law tí fíìmù ní I think September or July this year wípé àwọn family member European right of appeal.
Is the case of Salah.
Yeah. So only by this we need to think for the relation. Mo wá lọ wo website àwọn home office. So nígbà tí wọ́n ti àwọn judge tí wọ́n ti give judgment yẹn. So by September, I think September 22, wọ́n ti update the website wọn pé anybody tí wọ́n bá ti ní right of appeal pé wọ́n ní aláwọ̀ ẹ̀ mọ́. So bí judge yẹn ò ṣe padà aláwọ̀ kìíní ẹ̀ mọ́ nínú report yẹn tó send but ní kóòtù yẹn níjọ́ yẹn torí home office ò wá ó dẹ̀ confam ó dẹ̀ àwa méjèèjì ló béèrè lọ́wọ́ ẹ̀ púpọ̀ ní ṣé kìí ṣe pé bóyá ó fẹ́ kí nǹkan ní scripture nílùú ìwà ó ní no pé we are really planning to marry because we are really planning to marry so by this ó dẹ̀ ló máa allow appeal yẹn kó tó sọ fún mi lọ́jọ́ yẹn nìyẹn ìgbà tí ó máa send report so ó ní kò sí nǹkan tó ń lè ṣe pé the law has been changed.
Ẹ jẹ́ kí n wá sọ kinní kan fún yín gẹ́gẹ́ bí ọ̀rọ̀ tí mo sọ sí ìṣáájú mo ní orí ni èèyàn máa bọ́ gbogbo gbà lọ́wọ́ gbogbo ṣẹ́rí it is one thing for them to make their utter nonsense decision regarding not accepting human rights appeal. It's utterly nonsense. It is another thing for luck to be on your side on that day and have a good lenient judge.
Yes.
There is a recent case that we took to court. The father, the mother, and 4 children, depending on sister-in-law who is an European national. At the time the case was in court, the judge said that the law just came in last week, and as a result, he allowed the appeal, not knowing that the decision of that case law has come in. The Home Office attacked that judge straight away, and they took the case to the upper court, and the appeal was disallowed in the end. So they overturned the first judge decision and disallowed that appeal that was already allowed. So the same judge now sat in our case, on the case of the father, the mother, and 4 children, depending on their sister-in-law who is an European national. Bear it in mind, they've already granted them 5 years residence card. They were coming for permanent residence. They did it themselves and they were refused. They came to my office, we took the case to appeal. On that day, the judge said he was supposed to refuse that appeal. Am I gbọ́ mi dáadáa o? Case yẹn ti wà nílẹ̀, wọ́n ti ní ká má ṣe European appeal mọ́. Àwa wà ní court innocently. Because case ti wá wọ́n ti refuse appeal yẹn before that case was determined. Before Salah was determined. What it refused that Kisela to determine. So therefore, you should not just throw us away after when we have prepared, we have done everything, and this is a confirmed case. So at the 4 hours, we use all strength and bones. But to God be the glory. Aba ojú rere Ọlọ́run àti ti ènìyàn pàdé. Judge yẹn wojú mi, ó wojú applicants, all of them. Oh, the wojú sponsor is credible. So what the judge said is that he's not going to refuse this appeal. He's going to tell us to go away and go and do a proper research again and come back as to what we want to rely on the element of dependency. I now contacted the affluent QC in this country. We paid them good money to do the research. So the case law came back to overturn the decision, and we went back, and the judge gave us a few days to Christmas. So we were asked to come to court on the 21st of December. But we had to prepare for Christmas. But we went to court, and we spent another audible 4 hours in court. But in the end, what I want to say is that the judge allowed the appeal with immediate effect because the dependency element was convinced enough. So he ended up overturned that decision and said, listen, I'm going to allow the appeal. The sponsor is credible. She has a good job. She's a trainee solicitor. And there are so many receipts that we provided to show that they take money from her. There are so many things that she has done for that family. How come the law will change overnight and throw all these people onto the street? So we were allowed in court on the second term. But we didn't go to upper court. It was the same judge, Lower John. Lonika lọ ṣe research. Òun ni mo ṣe sọ pé téèyàn bá bá ojú rere Ọlọ́run àti ti ènìyàn pàdé, iṣẹ́ máa ń yàtọ̀ síra. Iṣẹ́ máa ń yàtọ̀, lọ́ọ̀kì ni gbogbo nǹkan, iṣẹ́ máa ń yàtọ̀ síra. So bó ṣe jẹ́ nìyẹn, but that particular case yẹn, ibi tó bá dé dúró, if you want to have my advice before you proceed with your lawyer, come to my office and let's have a look at it together and then I can advise. Okay? So that's just it. Good luck.
For how long do you normally take it for? Because the October is
Shebi check it yẹn ṣì wà in court.
No, take any action on the part.
I'm allowed to make a new application here, so you have to come to office for advice. What's office? What's office? All right, okay. All right, bye. I have to go now. Time is of essence. The next person is coming on program. But before I go, I want to quickly look at a question is that how do you bring in your fiancé to the UK legally? Now, you have to show evidence that there is a relationship between you and that person. The issue of income threshold will still have to be fulfilled. Otherwise, you have to let the person come in on our own to come and do marriage. And then go back, and then you can then bring that person in as your spouse. So bringing the fiancé is the same way. So I have to cut it short. If that question is not properly answered, please call me after this program on 07908 628240. Time is of essence. I have to go now. Thank you very much. I appreciate you all. Until next week. My name is Tokunbo Olagbaye. I remain humble. I cannot take phone call anymore. Time is of essence. Thank you very much. Bye. Hello. Yeah. Ẹ káàsán. A ti kúrò lórí studio nísìnyí, but mo ṣe wà live lórí Facebook. Lè sọ jẹ́ kí n kúrò lórí line náà tó lẹ́nu mi fẹ́ wọlé. Okay? Thank you. All right. Thank you very much. Bye for everyone. Bye to everyone. Thank you very much for all your support. You are all wonderful. You are all wonderful. You are the best. Thank you very much. I appreciate you. Excellent. Thank you. God bless you. God bless you all. Thank you. Thank you very much. Thank you. I remain humble. Thank you very much. Mo dúpẹ́ lọ́wọ́ yín o. Mo dúpẹ́ lọ́wọ́ yín. Ẹ ṣé gan ni. Ó dìgbà kan náà. Bye. You can call me in my office on 0208 309 8808 0208 309 8808 or use the mobile number online now to talk to me. Thank you. Bye.